In this session, we're going to explore how the proposed council approach to the one-stop shop, which looks likely, to me, to remain fairly intact through the trilogue process, how this would work in practice. So I'm Charlotte Mullarkey, and I'm joined by a hugely knowledgeable group of people here. So on the far end of the table, we have John Bowman, my co-chair from Promontory, and many of us met John in his previous role first at the UK Ministry of Justice, where he was head of the UK delegation to the Council's DAPIX working group, who was working on the regulation. I'm also joined by Florence, who needs no introduction. She joins us from the CNIL. Florence is involved in coordinating the CNIL and the Article 29 Working Party positions on the regulation. And Florence will be explaining today how she sees the one-stop shop working as a supervisory authority. I also welcome Laura. Laura is a privacy and security lawyer at Microsoft in the US. And unsurprisingly, Laura today will play the part of the data controller. And finally, delighted to introduce Karolina. Karolina joins us from the European Commission, where she was previously in the legal service, and now she's head of data protection reform within DG Justice. So as you're all intimately aware, I'm sure, since it was proposed in 2012, the one-stop shop has been on quite a wiggly journey. It's moved from Viviane Reding's vision, which Eduardo feels he said was idealistic, of each company having a relationship with a single supervisory authority. And it's moved to what some feel is a much more complex model proposed recently by the Council. And despite some key changes, such as the European Data Protection Board being able to make legally binding decisions, which Bruno mentioned earlier, it's interesting that the Commission does seem to support most of what the Council is proposing.
So I just want to talk briefly about the trilogue process, which you've heard quite a bit about. And of course, this one-stop shop will be subject to this trilogue. Trilogue is one of those interesting European words which are sort of made up a bit like comitology, subsidiarity, and paperology. So it's one, you can sort of work out what it is. It's a three-way trilateral discussion. You can see the brand new logos of the three institutions involved. It'll be a co-decision of the Parliament and the Council. So that's the Hemicycle in Strasbourg and the Europa building in Brussels. And they'll be advised by the European Commission, the Lemire building, who will provide mediation and technical support. What happens in a trilogue room? Well, no one knows. There's no rules. You could argue there's no transparency either. But in some ways, it's the way that deals get done. People stay up really late into the night, smoke-filled rooms or vapor-filled rooms, as is now the fashion. And really, they'll try and thrash out a compromise text. So if the compromise text is thrashed out, then there will be a council first reading. Hopefully, the European Parliament will agree that as a second reading position, and there'll be an early second reading agreement. So if the text is agreed by the end of this year, then we're looking early 2016 for it officially to be approved by the Council and the European Parliament. I won't go into the later stages. We want to avoid those. But if it does go to third reading agreement, it could be late 2016. It could potentially fail at that point, but only two files ever have failed at that point. So hopefully this won't be a third. So we'll move on.
There are lots of buzzwords in the Council's draft of the one-stop shop. I think, for me, the key change is the role of the concerned supervisory authority, which we'll touch on a bit later.
And for me, I think the concept of the relevant and reasoned objection. So effectively, this engages other concerned supervisory authorities, which we also have on there as well. And actually, this adds sort of interest and spice into the whole one-stop shop process, because effectively the DPAs get to cooperate and coordinate and try and work out a decision between themselves. And actually, how can we conceptualize the one-stop shop? So basically, we're looking at the three C's. So I know Eduardo very thoughtfully previewed some of these things for us as well, but maybe we can go into a little bit of detail. We have competence, which is set out in Article 51. So it's basically who is going to actually decide make the decision in terms of the complaint which is being lodged. It could well be the lead authority, which correlates to the main establishment in a particular territory, or it could be a local authority where a particular complaint was lodged or an incident took place. So once the competence has been decided, then it could go into a cooperation mechanism. So usually this will happen where a lead authority has been appointed, and then they will cooperate with all the other concerned authorities, and that might include the original local authority as well. And then if cooperation, the idea of cooperation is that draft decisions go backwards and forwards. If still no agreement, there's various cycles which they go through, but if still no agreement over that, then the third C is consistency. So this is the famous consistency mechanism, which of course involves the European Data Protection Board. And under the council version of the text, the decisions of the European Data Protection Board will be legally binding, which wasn't in the original Commission proposal. I should add actually that there is a fourth C, which I haven't put on there because I expect most of you would want to probably avoid it, and that is the CJEU. There's another innovation that Recital 113 does allow a route of appeal through to the European Court of Justice. So again, we've seen what happens when cases go there, but we'll leave that to one side for now, I think. So to introduce our scenario, anyone here into surfing? No? Brought your wetsuit with you? No, probably not the place for it, but there is a social network called weareboard.com. Get it? They're a social network for surfers, and you know, we surf the waves and we surf the web as well. So basically, we're engaging the surfing community, and this will be the subject of our scenario.
And obviously, we've headquartered our surf company in the land of surf in Australia. And this Australian company is represented today by Laura, who's moved recently from the US. And she has offices across 6 European countries and data subjects across the EU. So weareboard.com actually had a data breach. So how is that going to be dealt with in the one-stop shop? So we're going to introduce bring in our illustrious panel now. So I'm going to start posing questions. So the first question would be to Laura as our data controller. And that question is, what is your number one issue about this scenario as a data controller, where there's offices in various EU member states, but it's headquartered outside the EU?
Sure. So the number one concern for We Are Board or any business doing anyone operating in foreign markets is understanding what the requirements are. So it's going to be compliance, another C. As a company headquartered abroad in Australia, when you're operating in Europe, you want to be sure your business meets the local requirements. And data protection is an important regime in Europe, and particularly for a social network, you want to make sure that you're placing a high priority on those rules. So missteps can really result in fines, investigations, and reputational harm. And there are two kind of challenges with compliance today, and possibly even after the regulation comes into effect, albeit to a lesser extent. The first one is understanding the variations in the EU member state laws. And the second one is understanding which member state's law you're subject to. So on that first one, to some extent, the European data protection laws are harmonized, so the main principles you apply in one European market, you can apply to all of your operations. But albeit to a lesser extent, there are some variations in the details across member states. And understanding these nuances can be a big challenge. Harmonization will be helpful, but there are still divergences which will create uncertainty, and that makes investing and operating in Europe harder. The second one is, definitely compounding the compliance challenge, which is, what laws are you subject to? So the current tests, which are set out in Article 4 of the EU Data Protection Directive, have been subject to much debate, and we see the European Court of Justice giving us some more guidance, even recently with the AG's opinion on, Weltimo, I hope I'm saying that right. So we are seeing a little bit more guidance. Done properly, the one-stop shop idea provides greater clarity and some certainty for compliance. But the current concept, at least, I guess, one-stop shop, at least as it was first conceived, the social network or a company would be able to deal with one single regulator for all of its operations and based on the country where it's country of its main establishment. But unfortunately for We Are Board, we're seeing us move away from that and away from achieving the one-stop shop. We recognize that individuals need to be able to complain to the local data protection authority. It would be unexpected to have data subjects apply to foreign authorities. And in finding middle ground, it will be necessary to balance the need for clarity and simplicity on the business side against legitimate consumer interest. And this will be primary among one of the challenges for EU institutions and to resolve this in the coming months.
Thank you very much. So Florence, as a supervisory authority, what factors do you think you would look at to decide where Laura's main establishment is, and therefore who the lead supervisory authority would be?
Thank you very much, Charlotte. I think maybe first, before digging into this main establishment definition, and really to react to what Laura says, I think it's important, and Jen did it at the beginning, to recall the philosophy of the one-stop shop with the CNIL proposition, but also with the other propositions that are on the table. I mean, the idea is not to create an issue, it's to provide simplification and pragmatic solution for business that operates in different member states and that are implementing the same processing in different member states. So the idea is to avoid to have knocking on here on, I guess, 6 doors, and to have just one door, which will be the lead DPA, and the lead DPA will be a little bit kind of chef d'orchestre, orchestrator, in charge of the processing in terms of accountability. So all, if needed, the necessary request to a supervisory authority in terms, for example, of PIA. If I give one example of accountability tools and the relationship that it could trigger with a DPA, but also in the enforcement side, so with respect to complaints, to investigation that can be performed by DPAs and to sanctions. So the idea is to have a coordinated and organized and process around one processing for a company or several processing for the same company, in order to avoid, again, to have the company doing the job. So it's supposed to be to bring some simplicity. And the argument that now it's more complicated was I mean, the proposition on the table is because there was an issue at the beginning on proximity and on effective exercise of data subject rights. This right, as you know, is a fundamental right in the European Union that is protected as a very high level. Charter, convention, and also with the European text. And so we need to provide the data subject with the possibility to exercise its right on its soil. At the beginning, the proposition with the exclusive competence on the lead authority, the problem, the legal issue around that is that it obliged data subject to go, if the lead is on another foreign soil, to go on this territory in front of a foreign tribunal with a foreign procedure, foreign cost, foreign language. So it was really tough for the data subject. And this morning we were talking about the safe harbor and all the issue around the safe harbor and the effective exercise of data subject rights. Is it really the solution to have the data subject going in the US in order to exercise their right? Not sure. We have seen that it doesn't work. So the idea really is to have a balanced solution between simplification for the business and to have, again, one interlocutor, one contact point, and also proximity for the data subject. And last, and after I will go to the main establishment thing, last but not least, I think it's important also that the system is efficient, and so that's why we need to sit down and to work at the EDPB level in order to make it an efficient system. So now on the main establishment definition, I think that we have some interesting indication and clue in the text of the Parliament and the text of the Council, where I think I recall that it's about the establishment that is that have the power to take decision and to implement the decision. That's very important. It's one thing to be able to take decision, but also to implement it, because if there is a decision that is taken by the lead DPA and that will be enforceable against the main establishment, the main establishment should have the power to implement this decision among EU member states and among its establishments. So that's why it's an important factor. So the idea, it's a little bit linked to the BCR system in the sense that the company is the one that elect and appoint its main establishment depending on its local and European structure. So the company has to define which establishment is really the one that takes decision. That can be a headquarters. I think the term is explicitly mentioned in the Parliament version, but it can be also the establishment that has a responsibility for compliance in terms of privacy. So that's not necessarily the headquarters, and it goes. We find again the BCR criteria about designation of a lead, and after I'm done, but about the lead DPA. And we have seen that with the BCR system, if the check and balance is well done, and if the lead is really the one that is doing the job for the others, instructing the case, but that there is a balance with the DPA that still have the possibility to participate and to give their views, I mean, it's working, and there is in fact no issue around the lead. Today in BCR, we have, I think, 70 BCRs, a little bit more than that, BCR with lead DPA, and none have triggered a problem of designation of lead. We have never had, a conflict between DPAs about who should be the lead on this or this BCR. Why? Because again, there is a good balance in fact, about cooperation on BCR and about powers of DPA. And in this case, it's working quite well. So we should not maybe be too anxious about that.
Can I bring in Karolina here now? And so this concept of having the relationship with the main establishment is quite important. And also, if the companies from outside the EU, Eduardo made this point as well, you can't maybe not just say, I'm outside the EU. So if there is a choice available to a data controller, does this potentially open up the possibility of forum shopping? That's a famous term which is often used in this context.
Everybody is afraid of forum shopping.
Yes.
So no forum shopping after one-stop shop. It's over. One law applicable in one uniform way throughout the EU. Yeah. One continent, one law, what we were so often underlying. Why? Not only because it's a regulation directly applicable and no possibility of different kind of implementations on the national level. There is also the system of the one-stop shop, and here I would like to go back to the slide John showed us before. Two elements, consistency and cooperation. First of all, in the moment, there is a lead DPA involved because the main establishment of an undertaking is there, or because the decisions on the main decisions concerning the purposes and means of the processing are being taken in one particular member state. So we have the lead DPA, and we have another DPAs and other data protection authorities being concerned, as we call it. Now, they have to cooperate. They have to find a solution. They talk to each other. In the moment they cannot find a solution, it's enough that one is not happy with the solution found or the solution proposed, they go up to the European Data Protection Board. What is actually de facto the Article 29 working party now? And there exists the possibility to have a binding decision which will tackle all matters on which the DPAs among themselves could not agree, this is a binding decision. Yeah? So we have already these two layers. The layer of the cooperation, they talk, they agree. If they talk and cannot agree, up we go to consistency. One binding decision, which needs to be applied uniformly by data protection authorities. How it will work, the lead will prepare a draft on the basis of the binding decision from the board, and it will be then distributed among the data protection authority who jointly take the decision. So there is just no space for forum shopping. It will be a very uniform application of a uniform law.
Thank you. So Karolina sees a vision which sounds perfect, but I'm still not entirely convinced. There's one law I understand, and the consistency and the obligation to cooperate, but data protection authorities do have different reactions. They have different funding. I know that they'll look to change this, but Laura, I'm wondering whether, looking into the EU from outside, whether you would still be tempted to compare the regimes where you were going to set up your main establishment.
Sure. So I tend to agree with Karolina that the differences in the laws should evaporate. But I also think that, the fears about forum shopping are a little overblown. Even though the laws will be very consistent, you could have some smaller companies, maybe we are board, looking at regulators to figure out which ones are better resourced, which ones are really, which ones are more business friendly or more pragmatic. They could be looking at different regulators and, which ones they might, where they might be slowed down or which regulators are hostile. So there still might be some, particularly for smaller business, there might be some reason they might look at other regulators. Other reasons I think the fears here are overblown is that, especially multinational companies, we tend to design the products to the most stringent requirements, regardless of where they are. So we're going to design our products and services so that they meet the highest requirements. So there's not going to be a need to shop, which regulator we're going to want to speak to. Although small companies, particularly startups, Microsoft's 40 years old, so some of the companies that, when the regulation comes into effect, some of the coolest apps, we don't even know what those are going to be at that point. So they might have other incentives that are going to be different than a company like Microsoft. And then companies consider they consider many factors when they're looking at where to set up shop in Europe. They're looking at, where the talent is, where their vendors are, what EU member states have friendly business practices like tax. So, today, EU data protection reform is only one factor. It could grow, particularly with increasing fines, but we do think about many factors.
Thank you.
Okay. So we're going to come back to our scenario, and the We Are Board have determined that they're going to establish themselves in France, but a complaint is raised to the supervisory authority in Portugal. So effectively this invokes the competence part of the framework, and but basically the case would be offered to the lead authority, and you'd have 3 weeks to determine whether to take it or not. So what kind of things would you think about when you decide whether to take that case, which might be considered to be a local case?
Thank you, John. I think that the CNIL proposition already suggests some solution about that. It's what it's called local cases. If the breach impacts one person, one individual, or one establishment, we think that it makes sense that this case is dealt by the local DPA. There is also, we have to think also about the burden, the resources that request to the handling complaints. And I think we have a good example with the Google right to be forgotten situation, where it triggers some complaints, so I think at the CNIL it was around 350 complaints linked to the right to be forgotten. If we were in a situation, in this one-stop shop situation, with only the lead in charge of all cases, one lead in charge of all Google right to be forgotten cases, it will be a huge flows of cases just handled by one authority, which can be a problem from a practical point of view. And all cases doesn't necessarily need to be dealt by the lead. You can have like cases that remains at local level also. It's a way to ensure this proximity and to be in contact directly with the citizens and to reply to the problem. So I guess it makes sense that in some cases, in some situation, it remains at the national level. Which is very important is the information on that cases to the lead and eventually to other DPA, because it's a cross-border processing. We are always thinking about where we are in a situation we have the same processing implemented across Europe. So the lead is a kind of tour de control, a control tower, and she needs to know that there is one case that is dealt in Portugal with respect to this data breach, because it can be useful for the others also to know. It can be useful if there are other cases that are brought by other DPA. So if this case, the cursor is changing, we go to one infringement impacting several member states, multiple data subjects, so it becomes a certain issue that shared across Europe. So here the lead should play its role and make sure that there is also a consistent answer to this kind of complaint. So there is, I think we should have a good sense, I mean, a bon sens in the way we handle complaints when it's a minor. There was some discussion at the council about minor case compared to major cases. So that's the whole idea. When it's not too complicated, that it's impact one person, one establishment, it should maybe remain locally. It's also helpful for the lead not to be overwhelmed with work, but when it becomes a major issue, the lead should really be the one instructing the case, sharing its point of view in order that everybody can have the same consistent point of view. And in the right to be forgotten, it's exactly what we have done. It's a kind of, we are practicing, in fact, the management of complaint in a coordinated way. The important, we issued guidelines on criteria to handle complaints on the right to be forgotten. And so we make sure that we have more or less the same interpretation of our criteria among Europe, and that we are replying to complaints in the same way. So that's why the lead will play a key role.
So, Laura, very quickly, do you want to just comment on that? Does that fit with your picture of having a sort of one-stop shop idea in a relationship with one authority if local cases then get taken in other countries?
Sure. So the question really is the mechanism really going to provide some clarity to businesses? And to what extent the local authority can duplicate or override decisions by the lead authority? And the procedures that were set out in Article 55 and 56 of the draft GDPR, there was this mutual assistance and joint operations and sharing information, but the procedures also permit multiple investigations in tandem and to share information with each other as the investigation progresses. And in particular, Article 56 enables multiple authorities to pool investigatory powers and resources where a company has multiple establishments. So we agree that data subjects should be able to access support and go to their local authorities, but at the same time, there's a need to ask the question, is there a real need for each authority in this situation to pursue parallel investigations? And we think that this might create a risk that there might be differences in the laws, and also provide less clarity for businesses down the road.
Okay. So back to Karolina now, and I'll roll up a couple of questions in one, because conscious of time and we want to open up to the audience as well. But basically, if we go back to the previous slide, if a case is taken by the lead authority and it does go through coordination, then coordination mechanism. Well, how will that work in particular? What sort of considerations will the DPAs take into account? And then also if the cases end up going into the EDPB because a decision can't be reached or because a reasoned objection has been filed, will that create a logjam in the EDPB? I think Giovanni earlier mentioned that potentially they could only deal with 12 to 15 cases a year.
Yeah, first of all, we don't think that so many cases will end up in the consistency mechanism. Yeah? We think that within this box cooperation, the vast majority will be resolved, and it's what is going on now. And it was mentioned today during the first presentation how well Article 29, the Working Party, is working, and that authorities do speak with each other in all the cases now concerning Google and Facebook. So we do not, the system is not conceived in such a way that it's really, that each and every case will end up in the consistency box. Cooperation, talking to each other, trying to find a solution. Only if there is no possibility to find a solution, it's also a question, I mean, the peer pressure, the question of a prestige. Do I, as a data protection authority, do I really want to, go to the board, push for a binding opinion of the board and maybe be overruled? Maybe it's also from the point of view of my credibility, much more suitable for me to try to look for a solution, which is also much better for the business because it then goes quicker. And let's not forget, even if the authorities agree within the box cooperation, this is not were somebody not to be happy with it. There is always the possibility to go to the national court and end up with eventually in front of the ECJ with preliminary questions. What is also going on now, and it seems that it works. But, okay, so reasoned objection, board is switched in, board decides, two-thirds majority. If the two-thirds majority cannot be reached, fairly quickly, simple majority within the board, all DPAs talking to each other. If not simple majority, then the chair decides. And decision which will be addressed to the DPA, lead DPA who prepared the draft, and all the other DPAs. So they all have the possibility, since they will be addressees of the norm, to attack it with a direct action in front of the Court of Justice. There is existing a possibility to have expedited procedure in this case. It can go very quickly. It goes very quickly in merger area. It can go equally quickly here in the data protection area if the situation is requiring such an expedited decision. And so first of all, no. To clearly answer to your questions, no, I don't think that the EDPB will be swamped by reasoned objections, reasoned and justified objections, no. And secondarily, therefore, I also do not think that it will take for such a long time to take the final decision. Yeah,
okay, so a streamlined, efficient, one-stop shop system, hopefully in place when the regulation comes in.